Hello, I'm Jacqueline, and this is Murder Makers, a podcast on the criminal justice system. This episode will be discussing what happens from the time a person commits a crime to when they are sentenced. A crime. It is a legal right in the U.S. for them to be able to defend themselves. Some people choose not to do this. They instead choose to plead guilty for a crime, and what happens in that case is they go into a courtroom, usually with a judge and their lawyers. They plead guilty, and that usually results in a reduced sentence. Now, others choose to not plead guilty. They choose to fight their case in court. So that means that the accused will go to court and defend themselves against the accuser. So in that case, there's two sides to the courtroom. There's a judge and then there's a jury. And in this, the two sides present their cases to the judge and the jury as to why this person is guilty or not guilty. And it is the jury's job to decide if they believe that the person is guilty or not. And that is why we don't have one person on the jury, because it shouldn't be left up to one person to have to make that decision. Doesn't mean it isn't a very hard decision, because it's still a very hard decision for those people to make. But all of those people have to agree against juror consultants like Gen Silberkleit, my next interview, who I will be interviewing next, help decide which jurors do and do not make that decision. Today I'm here with Jen Silberkleit. Now, Jen is a jury consultant. So, Jen, what is the job of a jury consultant like?
So essentially what a jury consultant does is a jury consultant applies social science to the world of litigation. And when I say litigation, I refer to the very broad umbrella of people in disputes and companies in disputes and how they navigate through the legal system. And that legal system can be the criminal justice system, where somebody has allegedly committed a crime and is being prosecuted by the government. And then an entire separate silo is the civil justice system, where a person or company sues another person or company, usually for what are called money damages, trying to get compensation in the form of money to right a wrong. And the way the civil justice system, quote unquote, rights that wrong is through throwing money at it, because that is how our society functions. And what a jury consultant does is assist attorneys with everything social science related to help potentially neutralize biases in the process that might work against the client, or to help the attorney-client present their case more effectively.
So how do you ensure that there aren't biases in jurors?
One of the main ways that we, and I use the word ensure, I think, and you use the word ensure, and I want to take a step back and say there is no way to ensure that there is not bias in the legal system. Human beings think in ways that use cognitive shortcuts and make assumptions about people and things and situations, and any kind of assumption about a person, place, or thing, essentially those are biases if they're based on some kind of pre-existing notion or feeling that someone has that influences a present day judgment. So there is no way to completely turn off that human brain of making connections between things and being influenced by essentially biases. And we could have a whole other college semester focused on implicit biases versus explicit biases. And what I mean by that is implicit biases are the types of biases that people may or may not necessarily realize they have, but that are relatively less conscious and relatively more impulsive, versus more explicit biases that are the biases that people very clearly know that they have, and they may or may not try to inhibit acting on that bias or not. But there's essentially a difference between the implicit biases and the explicit biases, and the social science is very clear that implicit biases do exist and do influence people's decision making, especially when they're making decisions under uncertain circumstances, like a trial, when people are trying to figure out, which facts presented by each side are indeed facts and how to make sense of what they're being presented in trial. So it's by nature an uncertain situation. Back to trying to prevent the influence of biases. Jury selection is one major way that we do that in my field and in the legal system. So if we're talking about a criminal trial, there is a process called voir dire. If you are in Texas or parts of the South, it's called voir dire. But here where I am in California, we call it voir dire. I believe it's a Latin term, might be a French term. But that is the process of questioning prospective jurors in the courtroom and trying to identify whether they have a type of bias that is likely to influence their decision making about the case, and that they're not able to ignore enough to where it won't creep into their decision and essentially bias them. So the attorneys, sometimes with the help of a litigation consultant like me, will question jurors. The judge will sometimes also question the jurors. This questioning can be sometimes supported with an either paper questionnaire or electronic questionnaire to get some more information out of the jurors. But most often it is just done verbally in court, and the attorneys, and like I said, sometimes the judge will ask the jurors questions about how they feel about certain topics, trying to identify whether they have outside opinions or life experiences that are going to essentially bias the way that they think of this case and prevent them from being as close to kind of a clean slate as humanly possible, listening to only the evidence they hear in the courtroom to make a fair and impartial juror decision about the case. So that is one of the main ways that we try to sniff out bias in people, and we try to make sure that people who are too biased don't make it onto the jury. But there are, in the criminal justice system, for example, there are hyperbolically, a million ways that from the moment a police officer stops someone for a traffic stop, for example, all the way to when someone, like I just described, is sitting in court and potentially about to be judged by 12 strangers, the jury, there are ways to intervene on potential sources of biases throughout that entire process. So the way that a police officer interacts with someone can be influenced by biases. In a nutshell, any human interaction with a person, place, or thing can be influenced by biases.
What impact do jurors have on the case?
So the jurors have essentially the ultimate impact on a lawsuit, often. Not always, but often. The judge does have a pretty vital role, and different judges are more or less involved in how the case is handled in court. Judges act, for example, as the gatekeepers of the evidence, and so judges decide what evidence will or will not be put in front of the jury oftentimes. So in that way, the information that the jurors are supposed to be considering when making their decision can be influenced by the judge. But for many kinds of lawsuits and many kinds of trials, the jurors are the ones who decide, in a criminal case, for example, if a defendant is guilty or not guilty. And that is the process of questioning prospective jurors in the courtroom and trying to identify whether they have a type of bias that is likely to influence their decision making about the case, and that they're not able to ignore enough to where it won't creep into their decision and essentially bias them. So the attorneys, sometimes with the help of a litigation consultant like me, will question jurors. The judge will sometimes also question the jurors. This questioning can be sometimes supported with an either paper questionnaire or electronic questionnaire to get some more information out of the jurors. But most often it is just done verbally in court, and the attorneys, and like I said, sometimes the judge will ask the jurors questions about how they feel about certain topics, trying to identify whether they have outside opinions or life experiences that are going to essentially bias the way that they think of this case and prevent them from being as close to kind of a clean slate as humanly possible, listening to only the evidence they hear in the courtroom to make a fair and impartial juror decision about the case. So that is one of the main ways that we try to sniff out bias in people, and we try to make sure that people who are too biased don't make it onto the jury. But there are, in the criminal justice system, for example, there are hyperbolically, a million ways that from the moment a police officer stops someone for a traffic stop, for example, all the way to when someone, like I just described, is sitting in court and potentially about to be judged by 12 strangers, the jury, there are ways to intervene on potential sources of biases throughout that entire process. So the way that a police officer interacts with someone can be influenced by biases. In a nutshell, any human interaction with a person, place, or thing can be influenced by biases.
What impact do jurors have on you?
So the jurors have essentially the ultimate impact on a lawsuit, often. Not always, but often. The judge does have a pretty vital role, and different judges are more or less involved in how the case is handled in court. Judges act, for example, as the gatekeepers of the evidence, and so judges decide what evidence will or will not be put in front of the jury oftentimes. So in that way, the information that the jurors are supposed to be considering when making their decision can be influenced by the judge. But for many kinds of lawsuits and many kinds of trials, the jurors are the ones who decide, in a criminal case, for example, if a defendant is guilty or not guilty. And that is oftentimes left up to the jury. There are sometimes what are known as bench trials for certain kinds of cases, and that's when a judge makes that kind of decision. But I believe that more often it is up to the jury. So the jury does have the ultimate decision-making power, at least in regard to whether someone is found guilty or not guilty, or in a civil lawsuit, liable or not liable.
Does certain evidence impact jurors' decision-making more than others?
Yes, it does. Not only does certain kinds of evidence prove often to be more impactful than other kinds of evidence, but certain evidence is more impactful to certain people than it is to other people. So you kind of have this interaction effect where certain people tend to be more influenced by evidence A than evidence B, and other people tend to be more influenced by evidence B than evidence A. Take the classic murder case, and we have an alleged perpetrator of a murder who is the defendant in the lawsuit. And that person, for example, left a fingerprint at the scene of the crime. Their fingerprint was found at the scene of the crime. So to some jurors, that is enough evidence that they don't need to hear anything else. Perceived as hard scientific evidence, and the person was there, and there's no evidence that anyone else is there, and that is enough for them. For other people, a fingerprint might not be enough for them. Maybe they tend to just have a tendency to give people more of a benefit of the doubt or require a higher threshold of proof in their own head, regardless of what the jury instructions might be about how to consider the threshold of proof necessary. For example, in a criminal case, it's beyond a reasonable doubt. But what beyond a reasonable doubt means to juror A and what that means to juror B can be a very different threshold. So the law often does not match well with human psychology, it turns out. Psychologists did not design the law, judges and lawyers design the law. You can have things like beyond a reasonable doubt. So when there's a gap in a story, two different jurors might fill in that gap with an assumption about what probably happened that is very different based on their own personal experiences.
The order of evidence affect the jurors' view on that evidence or create a different storyline for them?
Yes, it can. Not always, but it can. One conceptual example is that information that people learn first can influence what they learn next. So if they accept one piece of information as true, or yeah, that sounds plausible, an example from the civil law world, individual differences in how they behave absolutely can make one person on a jury much more influential than other people. Fun side fact, people often assume that the foreperson, so the foreman or the forewoman of the jury, the person who essentially leads the jury through the verdict form and kind of helps structure the process of the deliberations, people often assume that that person is the most powerful in the room and exerts strong influence over the rest of the people. And that's not necessarily always the case. Oftentimes that person will focus on having this administrative role and making sure that everything is done, by the book and that everyone gets a chance to speak and doesn't actually influence the rest of the group, more than anyone else. Now, that's also not always the case. Sometimes the people who volunteered before people are the most boisterous, opinionated ones, but not always the case. So yes, in a nutshell, one person can have a really big difference. And especially if they're persuasive or, have a strong personality, they can steamroll other jurors.
So how does that play out if you don't want someone on the jury or you really do?
So sometimes they don't. The way that, taking a step back, one of the first things that I learned when I got into this litigation consulting field, same thing as jury consulting. I use litigation consulting, jury consulting, trial consulting. Those are all essentially interchangeable terms for the purposes of today. One of the first things I learned is that almost every single courtroom across the United States runs differently. So you think of the law as this codified, rigid legal formula of how everything works, but in practice, it is not the same anywhere. So the judge, like I mentioned earlier, has a lot of power over how his or her courtroom operates. Different jurisdictions have different laws that apply, and it's not the same from courtroom to courtroom. I will give a general overview of kind of how this jury selection process works, but know that it's not the same everywhere. But usually you'll have this jury selection process, the voir dire process of questioning the jurors, and a judge and the court will call in, for example, 60 people from the community. So people from whatever that jurisdiction is. Sometimes it's one county, sometimes it's a bunch of counties. It depends. And it depends if you're in state court or federal court, depends what state you're in. So there's all these different variables, but from wherever the people are getting pulled from, they randomly get selected based on voter registrations and driver's license records. Usually they show up in court and they come into the courtroom, and sometimes the judge does, sometimes the judge doesn't do their own questioning of the prospective jurors, the people who might end up on the jury. Other times it's left up to only the attorneys, and other times, especially in federal court, only the judge asks the jurors questions. But what happens most often, and this is a big what happens most often, but not always, is that the judge and attorneys representing each side of the dispute or the prosecution of a defendant in a criminal case, they will ask the jurors questions. They'll have a limited amount of time to do it, and sometimes the complexity of the case dictates how much time the judge will give each side to question the jurors. And like I mentioned earlier, sometimes you'll have a questionnaire that the jurors will fill out also. Sometimes you won't. But each side will be given a chance to talk with the jurors and ask them questions. There are a few topics that are off limits, but again, that is often up to the judge, what the judge will and will not allow the attorneys to ask the jurors. And the attorneys on each side have a limited number of what are called peremptory strikes. And again, depending on the jurisdiction, you might have 3, you might have 8, you might have more. Depends on the type of case, depends on the jurisdiction. Depends on the number of parties to the lawsuit. In a civil lawsuit, sometimes there'll be multiple defendants, for example, and each set of defendants, might have their own set of strikes. So a peremptory strike can be exercised for no reason at all, with some caveats. So if for whatever reason, the attorneys on one side think, I don't like that juror, I think that juror is biased, but the juror hasn't said they're biased or indicated they're biased, but I'm pretty sure that juror is biased, you can say, Your Honor, we would like to thank and excuse juror number 12, and you're using one of your limited number of peremptory strikes to get rid of that juror. And you can strike off the potential panel of jurors that juror. Now, each side also has an unlimited number of cause strikes. So strikes for cause. So for example, if someone admits a personal opinion or a personal experience that rises to the level of being too biased to be a fair and impartial juror, and the judge agrees, you can strike people from the panel and send them home to not be on the jury because they've expressed some kind of bias that would influence their thinking in an impermissible way. The judge is the ultimate decision maker of who does and does not stay for a cause challenge or a cause strike. And I will back up. I told you that there are a limited number of peremptory strikes where neither side needs to give a reason for why they're kicking somebody off. There is an exception to that. If the other side thinks that one of the attorneys is using all their peremptory strikes to kick off people who are of a certain race or of a certain gender or of a certain sexual orientation, those are not characteristics that you are allowed to kick someone off the jury panel for. And so they can challenge that, and the attorney who allegedly has been kicking someone off, for example, because they're all African-American men, has to come up with race-neutral explanations for why they have been striking those people. And they would do that privately with the judge and the other attorneys and explain why they're doing that, because you're not allowed to exclude people from the jury for their affiliation with a cognizable group, which generally is race, gender, sexual orientation. I think there's a few more now groups also. But in a nutshell, this is how the process works. A limited number of, I'm going to boot you from the jury for any reason, and an unlimited number of, ooh, you admitted bias, and I want to boot you because you admitted bias. And both sides will argue in front of the judge about whether someone's allegedly admitted bias rises to the level where they should no longer be allowed to sit on the jury. And that's a whole ordeal in and of itself. But that is generally how the process goes at a super high level and at a general level where, like I mentioned a million times before, it is not the same in every courtroom.
Well, thank you so much for your knowledgeable information and your time.
On this episode of Murder Makers, we discussed what happens in a courtroom when someone is being sentenced for their crimes. Special thanks to Gen Silberkleit for the interview.